very serious issues about Tob Cohen. One being that the same investigation report, the same forensic report that the Director of Public Prosecution used to charge one Sarah Wairimu and one Karanja is the same that pinned down one Justice Ole Katai. That double speak is a serious affront to the rule of law and to the position of the Director of Public Prosecution. Other than that, we have also raised very serious issues in the manner the Director of Public Prosecution now is saying he wants private investigators, foreign investigators to investigate this matter. Nowhere in Article 159 or in the Article 157 or within the DPP's Act does he have the mandate to look for foreign investigators. Why have Kenyans are asking? Millions and billions of money have been used to train our DCIs. Why are we going to foreigners? Why has he charged Sarah Wairimu? Why has he charged one Karanja? And yet he's saying the Director of Criminal Investigation, one George Kinoni, is incompetent.
Charging his functions, as is evident through a communication dated the 9th day of June 2021. The DPP, through his assistant, Senior Counsel Dorcas Oduor, writes on behalf of the DPP that in matters involving huge sums of money or persons who are deemed to be high in the rankings of the society, he should first be consulted before these individuals are brought to book or are charged before a competent court of law. So this in itself tells us that in the eyes of the Director of Public Prosecutions, he has people who are higher in terms of their ranking, and they should be accorded a different treatment in the manner in which if police officers are to arrest or if they are to be charged before a competent court of law. So in another perfect example, which is the most recent example, and we have seen it in the case of Directline Assurance Limited, where it is evident that now, since the owners of Directline Insurance Limited have the capacity to begin or commence public prosecutions, they can have their day in court. But what happens to other people in this country who have genuine criminal complaints, but they cannot have these individuals prosecuted through a private prosecutor? So that is the question. And if you were to look keenly into the file or the facts that have resulted into the complaint that has been levied by the directors or the Directline Assurance Limited, it's quite simple. There has been a squandering of a lot of money, to be specific about 4 billion shillings that has been squandered by individuals who are now untouchables in the eyes of the DPP. There are sacred cows that cannot be slaughtered or cannot be brought before the court to answer to their crimes. There has been failure to comply with statutory requirements at the bare minimum, which does not even require any investigator to go and bring in evidence before a competent court of law. But with a clear failure to apply or to accord with statutory timelines, the DPP has refused to move. He has refused to take action against 14 individuals who have not only stolen money, but have offended the direct provisions of the Insurance Act. So in a nutshell, what we are saying, and this is what the citizens should hear, is that the manner in which this public officer is exercising his powers requires that we, as the Kenyan citizens, or as it has been done by this individual who has petitioned, is that we should now petition, and this is not even a closure to the door. People should come out and petition against the removal of the Director of Public Prosecution for having failed in his exercise of his duties.